Welcome to this explainer. Listen, I'm going to need you to sit up and really pay attention right now, because today we are embarking on a high-stakes briefing. We're going to decode the exact laws that govern, well, literally our entire digital lives. I mean, think about it. Every text you send, every online purchase you make, every single piece of data you upload, it's all governed by a complex and rapidly evolving legal framework right here in India. We are going to break down the Information Technology Act of 2000, its massive amendments, the groundbreaking DPDP Act of 2023, and the landmark Supreme Court cases that are actively protecting your digital existence. All right, let's dive right into this. So we're taking a definitive journey through the 5 foundational pillars of Indian cyber law. First up, the rules of Indian cyberspace. Second, digital signatures. Third, cybercrimes and penalties. Fourth, data protection and privacy. And finally, IPR and cybersecurity. Let's get to it. Pillar 1, Rules of Indian Cyberspace. Now, the IT Act of 2000 was actually birthed directly from the 1996 UNCITRAL model, basically to deal with the explosive new realities of virtual transactions. But a huge question pops up. Where exactly does this law apply? Well, it has an uncompromising extraterritorial reach. Cyberspace obviously has no borders, and you know what? Neither does this jurisdiction. Under subject territorial jurisdiction, if you initiate a cybercrime from inside India, you're caught. Simple as that. But look at object territorial jurisdiction. Even if you're sitting halfway across the globe, if your act involves a computer or network located in India, the IT Act absolutely applies to you. Start the act here, or hit us here from outside. Indian law is going to prosecute. Moving on to Pillar 2, digital signatures and authentication. Okay, so we know the rules of the arena, but how do you actually securely prove your identity online without a physical pen and paper? Well, it's through this 6-step cryptographic guarantee. First, you generate an asymmetric cryptosystem pair, basically a public key and a private key. Then, you submit your ID to a certifying authority, or a CA. The CA rigorously verifies who you are and issues a digital signature certificate, effectively linking your public key to your real-world identity. Then, you sign documents with your strictly guarded private key, and the recipient verifies it with the CA records. And hey, listen up. Under Section 42, it is your non-negotiable duty to exercise reasonable care to retain control of that private key. If you lose it, you are compromised. All right, Pillar 3, cybercrimes and legal penalties. We're crossing into dangerous territory now. This is where digital breaches happen. And honestly, this is where the iron fist of legal enforcement slams down. Indian IT law firmly delineates between 2 distinct types of wrongs. On one side, we have cyber contraventions under Sections 43 to 45. Now, these are civil wrongs. So if you access a network without permission, maybe introduce a virus, or steal source code, you're facing massive financial compensation. We're talking up to 5 crore rupees, adjudicated by a government officer. But on the other side, we have cyber offenses under Section 65 to 78. These are criminal wrongs. This means active police investigation, regular courts, massive fines, and actual imprisonment. It is a completely different ballgame. Let's look exactly at what that criminal jail time looks like, because it gets intense. Section 66C covers identity theft. Fraudulently using someone's password or digital signature gets you 3 years and a 1 lakh rupee fine. Section 66E is for capturing or transmitting images of private areas without consent. That's 3 years and 2 lakhs. Section 67 is publishing obscenity, up to 5 years and 10 lakhs. But I really want you to look closely at Section 66F, cyber terrorism. Acts threatening the unity, integrity, or security of India through a computer. The penalty for that? Life imprisonment. Absolutely, life. The law does not play around here. But what happens when the law actually goes a bit too far? Let me tell you the insanely high-stakes story of Shreya Singhal versus Union of India. 2 young women in Mumbai were arrested for a simple Facebook post criticizing a city shutdown. They were picked up under Section 66A of the IT Act, which criminalized sending messages that were quote-unquote grossly offensive or caused annoyance. This arrest sparked a massive constitutional challenge. The core fundamental issue here: did this vague law violate Article 1911A, our fundamental freedom of speech and expression? While the Supreme Court dropped the absolute hammer in 2015, they unanimously struck down Section 66A in its entirety. Gone. They ruled that words like annoyance and inconvenience were just wildly overbroad and totally vague. I mean, a law capable of covering legitimate everyday speech creates a massive chilling effect on free expression. Therefore, it was ruled unconstitutional and completely void, just an absolute landmark victory for online free speech in India. But wait, the Straya single case actually tackled a second massive issue too, the liability of intermediaries. Think of your big social media platforms, search engines, or ISPs. Section 79 grants them what we call a safe harbor, basically immunity from being sued for what their users post. But of course, there's a catch. They have to remove unlawful content the moment they receive actual knowledge. The massive question for the court was, what exactly triggers actual knowledge? Can literally anyone just complain and force a takedown? So the crucial point is how the Supreme Court ended up defining this. They explicitly stated that actual knowledge strictly requires a court order or a government notification. It does not mean mere private complaints. And this is brilliant because it illustrates a vital safeguard. It completely stops tech platforms from acting as private, unaccountable arbitrators of free speech. They don't have to sit there and assess the legality of a post based on an angry user complaint. They just wait for the courts. Pillar 4, data protection and privacy. So we've talked about what you can say online, but what about the actual data you generate just by existing? We're talking about the ultimate shield of the digital citizen, informational privacy. To understand our new data laws, you really have to understand the epic 9-judge bench constitutional clash of KS Puttaswamy v. Union of India. Following massive challenges to the biometric Aadhaar scheme, the Supreme Court had to answer the ultimate defining question. Is the right to privacy actually a fundamental right under the Indian Constitution? Because for decades, older rulings had said it wasn't. The 9-judge bench delivered a unanimous, history-making verdict. Yes, the right to privacy absolutely is a fundamental right under Article 21, the right to life and personal liberty. And crucially, they explicitly stated that this includes informational privacy, meaning the right to actually control your own personal data. This 2017 ruling completely overruled decades of old law and forged the absolute constitutional bedrock for all modern Indian data protection. And thanks to Puttaswamy, we now finally have the DPDP Act of 2023. Now, you need to grasp two rapid-fire definitions here to understand exactly who holds the power. First, you are the data principal. You're the individual the data actually relates to. Then, the business or platform you give it to, they are the data fiduciary, the entity determining the purpose and means of processing that data. And the golden rule now, the fiduciary requires your free, specific, and totally informed consent. And if a data fiduciary fails to implement reasonable security safeguards to prevent a personal data breach, listen to this. The Data Protection Board can hit them with a staggering maximum penalty of up to 250 crore rupees. Wow. Just let that sink in for a second. 250 crore. That is the very real price of failing to protect the digital citizen's privacy today. Finally, Pillar 5, IPR, cybersecurity, and forensics. This is our final arena, the battleground of protecting digital creations. In the high-stakes world of intellectual property, your domain name is highly, highly valuable. Cybersquatting is a major threat here. This is when someone registers a domain similar to a well-known brand, basically to extort them. But Indian courts are incredibly fierce about this. In cases like Tata Sons v. Manu Kusuri and Yahoo Inc. v. Akash Arora, the courts definitively ruled that domain names are protected trademarks. Registering yahooindia.com just to ride on Yahoo's reputation, that was struck down as passing off. So yes, your brand is fiercely protected in cyberspace. But let's say you've been hacked or your IP is actually stolen, and now you have digital evidence. How do you present something entirely invisible, like lines of code or bit-by-bit hard drive images, in a physical court of law? Well, this brings us to the absolutely crucial case of Anwar PV versus PK Bashir, which established the rigid legal threshold for cyber forensics in India. The Supreme Court laid down an absolutely unequivocal rule here. To admit any electronic evidence, a certificate under Section 65B of the Indian Evidence Act is mandatory, period. This certificate basically proves the computer was operating properly and the data wasn't tampered with. Without this Section 65B certificate, your hard-won digital evidence is entirely dead on arrival in an Indian court. They won't even look at it. And who is watching the perimeter while all of this is happening? Under Section 70B of the IT Act, that job falls to CERT-IN, the Indian Computer Emergency Response Team. They are the absolute national watchdog for cybersecurity. And under their 2022 directions, there is an unyielding, mandatory rule. Any severe cybersecurity incident must be reported to them within exactly 6 hours. 6 hours. No exceptions, no excuses. So we've covered the established law, but what about the wild frontiers? Cyberspace literally never stops expanding. Today, our legal framework is being pushed to its absolute breaking limits by emerging issues. We are talking about totally unregulated artificial intelligence and deepfakes, the incredibly volatile status of cryptocurrencies, the massive, sprawling security risks of the Internet of Things, decentralized blockchain smart contracts, and of course, the explosive growth of real money online gaming. Which leaves us with this final burning thought to wrap up this explainer. The IT Act of 2000 and the DPDP Act of 2023 give us an incredibly powerful arsenal. But as AI rapidly evolves to basically think for itself and blockchain technology works to completely decentralize our reality, is our current legal framework truly fast enough to catch the future? That, my friends, is the ultimate question for the next era of the digital citizen's journey. Thank you so much for joining me on this explainer. Stay informed and stay secure out there.